Hi everyone, my name is Melissa, and the case that I decided to do my case brief on is Stanley v. Georgia, which was decided in 1969 by the U.S. Supreme Court, but the Supreme Court did not have original jurisdiction in this case. This case actually started in Georgia at the trial court level involving a man named Robert Stanley, and Georgia officials suspected Stanley of bookmaking and gambling, and they went with a search warrant to his house to search for evidence of the bookmaking. But what they actually found instead of the bookmaking materials was 3 rolls of 8mm rolls of film that contained what they called obscene material. And when they found that, they watched the tape and then they charged Stanley with possession of obscene matter, which was in violation with Georgia state law at the time. So because of this, at the trial court level, Stanley was found guilty, and then he appealed to the Georgia State Supreme Court, was found guilty again, and the court made their ruling based on the case of Roth v. United States, which stated that obscenity is not within the area of constitutionally protected speech or press. And the state of Georgia also affirmed that Stanley's personal possession of the films was with the intent to sell or expose them. So then that's when Stanley appealed his case to the U.S. Supreme Court, and they agreed to take it. So Robert Stanley appealed to the U.S. Supreme Court on the grounds that he believed his First and 14th Amendment rights were violated. So there were two issues in this case, first being the First Amendment issue and the second being the 14th Amendment issue. And regarding the First Amendment issue, the Georgia statute regarding obscene material makes private possession of obscene material a crime, which violates your First Amendment, violating your privacy. The 14th Amendment issue is that this amendment, the 14th Amendment, makes the First Amendment applicable to the states, and in this case was also violated because the First Amendment was in violation. The court's holding of whether or not the First and 14th Amendments were violated, both answers were yes, and the reason that they said the First Amendment was violated was because it is the constitutional right to receive information and ideas regardless of their societal worth, and that is fundamental to the freedom of our society. And then regarding the 14th Amendment, they also said that it is a fundamental right to be free from unwanted government intrusion of one's privacy and thoughts. And because he had the tapes securely in his own home for his own private purposes with no intent to distribute or expose them, then he had the right to have those. And to add on to that, the First Amendment is made applicable to the states by the 14th Amendment, and it says that states cannot make private possession of obscene materials a crime or use the excuse that it may lead to antisocial behavior. So the reason behind these holdings is that Stanley had the right under the First and 14th Amendments to have these materials in his own home, as they were not affecting anyone else, and the search had violated Stanley's right to privacy. The U.S. Supreme Court expressed that the First Amendment values that a state has no business telling what books or what films someone may watch within their own home. And the state of Georgia could not use the Roth v. U.S. case to affirm their reasoning, because in that case, Roth was mailing / distributing and advertising obscene matter, which was in violation of a federal obscenity statute. So in Stanley's case, that the matter at hand was entirely different, as he was privately possessing and viewing the obscene material. So this case established that states may not make private possession or viewing of obscene material a punishable crime, as it violates the First and 14th Amendments. The state of Georgia tried to use the decision in Roth v. U.S. as a reason to prosecute, but made the mistake of applying it to this specific context of Robert Stanley's case, which differed from Roth's case. So that's all I have. Thanks, guys.